I'm Brent Iverson, Dean of the School of Undergraduate Studies. I hope you enjoyed the dramatic countdown to this evening's events. Since the video is 3 minutes long, it should be still going, and you can see here we are. If I ask you to guess the purpose of this Franklin elapsed time indicator, you might think that it's a stopwatch for snail races. It's a timer for watching paint dry. Maybe a countdown in years for when the Aggies are actually going to win a football game. I don't know. In fact, in the mid-20th century, when the Franklin elapsed time indicator was created, it was considered state-of-the-art technology for helping students learn to speed read. Now technology has evolved, and thankfully, so have our ideas about reading effectively. UT Sanger Learning Center, which is where this piece of equipment used to live, has changed too. From 1949, when returning GIs needed reading support, to the Cold War, which put a spotlight on math and science preparation, the Learning Center has evolved to meet the needs of each new generation of Longhorns. In 2018, in response to financial pressures on UT students, the Sanger Learning Center moved to make tutoring in more than 70 subjects 100% free. And in 2020, in response to requests from students who live and work off campus, the center will begin to offer online tutoring in addition to face-to-face tutoring. Many of you have probably already visited the Sanger Learning Center for workshops, coaching, and tutoring. For those of you who haven't made it yet, I urge you to take advantage of this UT institution. I hope you'll join me in wishing the Sanger Learning Center a happy 70th birthday. All right. Now, for this evening's presentations. One of the most important things you can learn in college is how to analyze, investigate, and then discuss complex and even controversial topics. It is often a difficult situation when two thoughtful and reasonable people realize they disagree about an important issue. Many are concerned that in our society today, we are losing the ability to discuss difficult or controversial topics in an appropriate way. This evening, we have some of UT Austin's finest faculty for you. We are going to hear about a difficult and controversial topic, the death penalty. Our goal is not to change anyone's mind, but rather to model scholarship, analysis, and thoughtful discussion of a complex issue. At the end of the three presentations, I will be asking the panel of speakers your questions that we received by Twitter. So please, as they're presenting, send your questions in according to the tweet right at the bottom there. First up is Professor Jordan Steiker. He's the professor in the School of Law, as well as the director of the Capital Punishment Center at the UT Austin School of Law. He is a world-renowned expert on the legal issues related to the death penalty. Dr. Steiker?
Good evening. The American death penalty occupies an odd position. On the one hand, the United States was early in its reform of the death penalty. In the 1790s, Pennsylvania created degrees of murder with the express purpose of permitting some murderers to avoid the death penalty, whereas in most parts of the world, all murderers faced death. Two American jurisdictions, Michigan and Wisconsin, were among the first jurisdictions in the world to abolish the death penalty when they did so in the mid-1800s, and they've never reinstated it. And from the founding until the late 20th century, the United States was at the forefront of reforming various aspects of the death penalty, eliminating mandatory sentences, creating mechanisms for reviewing convictions, ending public executions, and so on. Yet today, the United States is a wild outlier in the opposite direction, standing as the only developed Western democracy to retain the death penalty. And its retention is not a mere formality. The United States not only has the death penalty on the books as an available punishment in many states and in the federal government, it also actually carries out substantial numbers of executions. In fact, today, the United States is among the leading executing nations in the world, alongside China, Iran, Saudi Arabia, Iraq, Vietnam, and Egypt, countries with whom we otherwise have little in common in terms of our politics and culture. It's hard to overstate the divide between the United States and other democracies around the death penalty. Over the past half century, the death penalty's decline worldwide has accelerated to an extraordinary degree. In 1965, only 25 countries were in the abolitionist camp. By 2018, 106 countries had legally abolished the death penalty for all crimes, and another 36 countries were deemed de facto abolitionist by virtue of not having carried out any executions in the preceding 10 years. This shift has occurred in large part because democracies around the world have ceased to view the death penalty issue as one of criminal justice policy, and instead as a fundamental issue of human rights, with the lion's share of countries in the world viewing the death penalty as incompatible with human dignity. For example, in addition to making death penalty abolition a condition of membership, the European Union has made it an imperative to end the death penalty worldwide, devoting substantial resources to that effort. It's fair to say that death penalty abolition is a defining part of European identity. Why has the United States not joined this global movement? There are several theories of American exceptionalism with respect to death penalty retention, including cultural explanations, our higher rates of violent crime, our religiosity, our racial divide, and structural explanations, particularly American federalism, which assigns criminal justice choices to the states rather than to a unifying federal government. On this score, it's worth noting that the United States death penalty is not monolithic. Only 29 states presently authorize the death penalty, and a much smaller set of states is responsible for the vast majority of death sentences and executions. For example, Texas has carried out almost 40% of the nation's executions over the past half century, close to 600 executions out of the 1,500 or so nationwide. 3 states, California, Texas, and Florida, currently house about half of the nation's death row. Will American exceptionalism continue? There are unmistakable signs that the American death penalty is weakening. Executions have declined substantially from a yearly high of 98 executions 2 years ago to only about 24 a year over the past several years, representing about a 75% decline. In the past 2 years, popular support for the death penalty dipped below 60% in the Gallup poll for the first time since 1972. 9 states have abandoned the death penalty since 2007, from the Northeast, the Midwest, the Southwest, the Far West, a remarkable surge in abolitionist activity. The last previous repeal, not triggered by a judicial decision, was in 1965. But by far the most important development has been the astounding fall in capital sentencing. Death sentences have declined more than 85% from their mid-1990s highs. To put this in local perspective, in 1999, Texas sentenced 48 defendants to die. This year, to date, only 1 person has been sentenced to death statewide. What has caused this weakening? Most observers point to a series of exonerations in the late 1990s as a turning point in the American death penalty. 13 death-sentenced inmates in Illinois alone were found to have been wrongfully convicted. It seemed unimaginable that so many death-sentenced inmates could have been sentenced to death for crimes they had not committed. In addition, the advent of life without possibility of parole sentences as essentially the sole alternative to the death penalty for aggravated murder seems to have reduced the appetite of prosecutors and jurors for capital punishment. That certainly seems to be the case in Texas, where life without possibility of parole became law in 2005. Finally, capital litigation has been transformed over the past 50 years, such that capital trials are much more time-consuming and expensive. The sheer costs of capital cases have deterred prosecutors from seeking the death penalty frequently, and the increase in resources has improved capital defense practices, especially in terms of investigating mitigating evidence supporting a sentence less than death, such that prosecutors are less likely to obtain death sentences when they go to trial compared to about 25 or 30 years ago. To give a sense of the outsized costs of capital litigation, consider this. A landmark study of California looked at all of the costs in capital cases leading up to an execution, including the extra trial costs, the appeals costs, and death row incarceration costs. The study revealed that if you took all of the additional costs in capital cases statewide and divided them by the 13 executions California has carried out over the past 40 years, you'd arrive at the following staggering figure. Each execution in California has cost the state approximately $250 million. It says something about our politics that concerns about cost have contributed significantly to the reduced footprint of the American death penalty, in contrast to the largely human dignity, fundamental human rights concerns that have accounted for the death penalty's rapid decline and abandonment abroad. Despite this weakening in the United States, it's hard to imagine all of the remaining 29 states with death penalty statutes on the books repealing their capital statutes. And because of our federal structure, it's not at all clear that Congress, were it so inclined, could legislate nationwide abolition of the death penalty. If abolition comes, it will have to come in the form of a decision by the United States Supreme Court declaring that the death penalty is inconsistent with the Eighth Amendment, which forbids the imposition of cruel and unusual punishments. The court came close to such a decision before, in 1972, when it declared that prevailing capital statutes were unconstitutional because they facilitated the arbitrary imposition of the death penalty. But that decision was greeted with significant backlash, and the death penalty emerged more stable than it had been before. What are the prospects for such a decision today? Is judicial abolition in the cards? A recent Supreme Court decision suggests that the current court is not at all inclined to invalidate the death penalty. In April, new court appointee Justice Neil Gorsuch addressed the death penalty in a decision challenging the application of Missouri's lethal injection protocol. As part of that decision, Justice Gorsuch stated that because the death penalty is constitutional, there must be a constitutional means of carrying it out. That comment was not new. The court had said essentially the same thing in two prior lethal injection cases. What was new, though, was Justice Gorsuch's explanation of why the death penalty is constitutional. He argued that the death penalty is contemplated in the text of the Constitution. The Due Process Clause of the Fifth Amendment, for example, states that life, liberty, or property should not be taken without due process, implicitly suggesting that life, liberty, and property can be taken if appropriate procedural protections are observed. Justice Gorsuch also noted that the death penalty was widely available at the founding. Based on these two considerations and his originalist methodology, Justice Gorsuch argued that the issue of the death penalty's constitutionality is essentially foreclosed. It remains a choice open to the states, a choice that the court should not withdraw. this textual, historical, originalist approach to the death penalty's constitutionality is in substantial tension with the court's long-standing Eighth Amendment doctrine. Since the late 1950s, in interpreting the Eighth Amendment, the court has focused on whether a challenge practice is, quote, consistent with evolving standards of decency, unquote. Under this approach, it doesn't matter whether at the framing certain practices were tolerated or indirectly textually supported by the Constitution. For example, the text of the Fifth Amendment also implicitly suggests that offenders can be deprived of life or limb, though few observers think states could constitutionally impose corporal punishments akin to amputation. Instead, the evolving standards of decency approach seeks to gauge whether society has turned its back on a punishment by looking at state statutes, sentencing practices, polling data, expert opinion, world opinion, and so on. The court has also consulted its own judgment in interpreting the Eighth Amendment to assess whether a punishment meaningfully serves permissible penological purposes, such as deterrence and retribution. Over the past 2 decades, employing this methodology, several justices, including 2 on the current court, Justices Breyer and Ginsburg, have suggested that they believe that the death penalty may no longer comport with evolving standards of decency. They have suggested that the very rare imposition of the death penalty, along with the risk of wrongful convictions and its discriminatory administration, may have made the death penalty inconsistent with the Eighth Amendment and violative of the prohibition on cruel and unusual punishment. But Justice Gorsuch's recent majority opinion reflects an effort to close that door and to require that the death penalty's ends must come, if at all, through a state-by-state process of repeal, an exceedingly unlikely prospect. Justice Gorsuch's approach also implicitly calls into question several court rulings which have relied on the evolving standards of decency approach, including the exemption of juveniles from the death penalty, the exemption of persons convicted of non-homicidal offenses such as rape, and the exemption of persons with intellectual disability from the death penalty. Ultimately, the future of the American death penalty, at least in the short term, will turn on whether the textual, historical, originalist approach of Justice Gorsuch or the evolving standards of decency approach of the past 60 years will emerge as the prevailing standard. The court is closely divided on this question, and small changes to the composition of the court have the potential to radically alter the prospects for judicial abolition, at least in the short run. In the long run, though, the American death penalty seems destined to end. It is already dying, with death sentencing being the single most important leading indicator of its future status. But more importantly, the current divide between the United States on the one hand and virtually all of the developed democratic world on the other seems unsustainable. Death penalty retention will increasingly impose costs on the United States and will become an obstacle to joint political and economic goals. Perhaps more importantly, future generations of America will likely join our democratic peers in framing the death penalty issue as one involving human dignity and human rights, and increasingly urge its rejection on fundamental moral rather than merely pragmatic grounds. Given the speed and depth of the consensus developing outside of the United States and the dramatic withering of the death penalty at home, it is hard to imagine the death penalty being a part of the American landscape 20 or 30 years in the future. Thank you very much.
Our second speaker is Dr. James Patton. He's an associate professor of instruction in the Department of Special Education in our College of Education. He is also an expert witness called in to establish competency of capital punishment defendants. Dr. Patton?
All right. Good evening, y'all. Thanks for coming. I first of all want to just say it's great to be, well, first of all, I'm honored to be a faculty member here at UT, and I'm very happy that I've been invited to be part of this distinguished group of folks presenting to you. So let me get going here. So I've entitled this kind of a personal professional perspective because I'm going to do a slice of what Jordan kind of set up. So let me kind of get to it. I'm going to start with this piece. If you're looking for a gift for folks, this book might be a good one. It's called Rules for Aging. It sounds like it's something for me, my age, but the point is that Rule 16, don't go to your left. It's a basketball term, and what it basically means is that don't try to dribble if you're left if you're only good dribbling with your right. So I'm going to stay with what I know here tonight. And what I know, my background, and as Dr. Iverson has said I have been working in the death penalty area for quite a while now, and I'll give you a little sense of that. But I look at basically one particular area, and that's individuals with intellectual disabilities. So let me get to that. I have two stories I'm going to tell you tonight. One is kind of a personal story. And that is, how does somebody that's basically a special education teacher become someone involved as an expert witness in death penalty cases? So that's one storyline that I will have woven in here. And the second storyline is I want to share with you some of the issues related to individuals with intellectual disabilities who are charged with or have found guilty of committing a capital crime. So both of those things is what I'm going to try to do in the next couple of minutes. I'm going to give you a real quick hit on where I come from. So I show this. I don't know if you can see it real well. This is a little sidebar. This is a grade report of mine from a few years. I went to the University of Notre Dame. At the time, I was thinking about going to medical school. If you look closely at the grades, kiss that goodbye. But I show this to you for one reason, is that well, if nothing else, if things don't go well, you can repair. I did repair. I did become a high school biology teacher, so that started my kind of area, my career in teaching. I had to do some military service, so I did that. When I got out of the military, fortunately, you saw my GPA there. The University of Virginia only looked at the last 2 years of your undergraduate program. So I got into the master's program, and that's where I started getting involved with individuals with special needs. It just so happened that one of my areas of specialty was intellectual disabilities. I'm going to use a term that we don't use now, but I'm going to use it because you'll see it once or twice historically. The term intellectual disabilities was formerly referred to as mental retardation. It's a term we don't use now, but it will come up. So my point is I got into the master's program in special education, and then after that, my career dealing with basically the first two were as a special education teacher. That is what I was for quite a while. And then in more recent years, I've been involved with a lot of programs dealing with adults with intellectual disabilities, some here at UT and some elsewhere. I moved to Austin in 1990 from when I was teaching at the University of Hawaii at the time. Came here to Austin and have been in the College of Education ever since. But my life changed in 2003. I'll get to that in a second. It really was because of 2002. In 2002, there was a Supreme Court decision, Atkins versus Virginia, which basically, and Jordan talked about this, that decision made it so that individuals with intellectual disabilities could not be executed. So now there was this new kind of venue, if you will, for people, and everybody needed to know what this was all about. Let me kind of move through this. I was going to talk about that, but I'm not now. In 2003, in the same week, I might be making this up, I think it's the same week, two things happened. I got a call from the Texas Criminal Defense Lawyers Association to do a training for lawyers on intellectual disabilities. And in that same week, I got a call from actually some lawyers who had a case where they thought the individual they were defending had intellectual disabilities. At the time, I didn't know, I was intrigued by the whole idea, so I said yes to both. And I have not gotten out since. I have been behind razor wire way more than I ever would have thought as somebody that is a special education teacher. The good thing for me is I leave. If you don't know what intellectual disabilities is, I want to give you just a quick hit, because this is where I want to go, and I want to, through my stories, I want to share a couple things. First of all, intellectual disabilities has 3 components to it. Component number 1 is sub-average intellectual functioning. We usually determine that through IQ scores. And what it really means here is 2 standard deviations below the norm, and most of you in here would know what that is. We're looking at IQ scores around 70. And there is some latitude there, of which I'm not going to be able to go into in all the detail today. The second prong, we call them prongs. I never called them prongs until I got involved with the legal stuff. Prong 2 is deficits concurrently. There needs to be a deficits in adaptive functioning. That's what I do. And I'll come back to that in a second. Again, you need to show significant deficits in this area. And the third one is this condition has to be manifest during the developmental period. Historically, that has changed a couple times, but more recently it has been dictated as age 18. I think many of you in here would probably agree with me that the developmental period really goes into the mid-20s for sure. And so I think and there are some changes to that. Okay. Individuals with intellectual disabilities, yes, they may have deficits in everyday living kinds of things. Maybe they have deficits in the way they process and reason, but they have strengths. And this is a very, very important piece, particularly the storyline of folks who get into the criminal justice system. That's not needed. I already kind of told you what I do is I do the adaptive behavior assessments. This particular image was my attempt, cost me $200, to get this idea of what I want to share now with you is the experience that I've gone through and some things I want to share with you about working in the death penalty system. First of all, this is for me, JRP. I was completely naive. When I got involved with this, I thought for sure, hey, wait a second, the school records show that this person was in special education and this person was identified as having intellectual disabilities. I thought, it's over. I think we got it. I found that's not the case. You are still, as a defense team, going to have to really prove that this person does have intellectual disabilities. So my naivete, it went beyond that, but that was one of them. I want you to take just a second. And if I asked you to describe someone for me who has intellectual disabilities, I would be really interested in knowing how you would describe that person. Some of you will describe that person because it's a family member. You described it pretty well. Some of you will describe it because, oh yeah, I went to school with someone. Yeah, they maybe in a special ed class. But I think a lot of us a lot of us don't have that kind of experience. And our images come from our conceptualization, or our stereotype comes from media a lot of times. One that I'm going to refer to, and I don't know if when I ask you to think about it for a second, if Lenny from Of Mice and Men comes up, but this is actually a fairly interesting stereotype because, well, for a number of reasons, but one, it has been used here in Texas as we call it the Lenny standard, that if for someone with intellectual disabilities, if they don't somehow resemble Lenny, who, by the way, was a fictional character, they don't have intellectual disabilities. Now, here's the problem, is that Lenny's fictional. I could do an assessment, maybe. I really can't. But the thing is, we might agree that maybe Lenny does meet the criteria, if we could assess him in some fictional world, that he has intellectual disabilities. But it's a narrow slice. Most of the folks, and up at this point in time, I have been involved in about over 40 death penalty cases where I've been what I call heavy lifting. I've done lots of work, probably been involved with 60 plus cases in some way, shape, or form. None of the cases that I've done has any of the clients looked like Lenny or presented as Lenny. So we've got some issues here. There are some misconceptions. And I'm reading it. I want to share this with you because this is what's key for me. I spend a lot of my time dealing with misconceptions of what intellectual disabilities is. I want to show you this. I started off, this person is not ID if he or she. I have worked one female case, but all the rest have been males. I'm sorry the font size isn't so large, but these have all come up in cases that I have worked. He couldn't possibly have intellectual disabilities if he looks normal. Are you kidding me? Come see me. We'll spend some time. I'll show you a whole lot of folks with intellectual disabilities, and they don't look any different than anybody else. I'm not going to go through all the bullets, I promise. I do want to jump down to the one that says, has friends, including girlfriends. Really? Folks, I've spent a lot of time around individuals with intellectual disabilities. They have friends. Sometimes they may be more superficial, but sometimes they're very, very important ones. They have girlfriends and boyfriends. They get married. They have spouses. Column 2. Can drive a car. You know, driving a car isn't that difficult. Now, when they have the driver's license part, there are some pieces that get involved with there. But I'll tell you, I have data that will show that a certain percentage of folks with intellectual disabilities do have driver's license. So you don't just, categorically dismiss that because of this. And there was one other one I was going to do up here, can get and keep a job. That's what we're about. See, I live in a kind of two different worlds. Right now, I'm living in the world somewhat of deficit, because that's what I have to do in this death penalty work. But outside of that, in my role in special education, it's all about positive, it's all about strengths, it's all about empowerment. So this stuff's hard for me to look at deficits. But I'll tell you, one of the things we do is we teach folks how to get jobs and keep jobs, and they can be wonderful workers. So none of these things should categorically exclude somebody from having intellectual disabilities. I wanted to just say one thing. It's called IDness. But what I wanted to say is there was a book written in 1967, a long time ago. It was called Cloak of Competence. It is a fascinating book, and many of the tenets in there still hold. One of the tenets is that individuals with intellectual disabilities they don't like the term retarded or being called that, and they will deny their intellectual issues. Number 2, they will try to pass as typical or as like everyone else, and they'll do lots of things to cover that. And number 3, Edgerton, who wrote the book, Cloak of Competence, mentioned that there's often benefactors. In today's world, we call them supports. You will see supports in their lives. And I think that's a really important thing, because as we do this work, or as I do this work, those are all things I have to consider. I've had some amazing experiences in my work with the death penalty case. These 3, and I wanted to put the cultural piece up, because in every case I've ever worked, culture is extremely important to understand. Whether it's somewhere in central Louisiana or whether it's Houston, there's a cultural piece to that, no matter who it is. I have worked some pretty interesting cases in terms of a Somali pirate. I've worked a case where the individual was Amerasian. So this is somebody that was, and he came to the U.S. In his teens. I've had to go to Vietnam. I've gone to Guam. I have to go and meet the families, meet the people that know these individuals. I didn't make it to Somalia. SEAL teams weren't available. I want to end with a story. This is a Texas case, and I'm just going to say a couple things about it. I wanted to tell us a little bit more, but I need to cut it down. This is Clifton Williams. Some of you may know about the case. It comes out of Smith County up in the Tyler area. Clifton Williams has a whole bunch of issues. He was involved, he was convicted of a crime in 2005. I'm not going to go through the crime, doesn't matter for my point. In 2006, there was some indication that he might have intellectual disabilities. So I was contacted and I got involved with the case. This particular case, I learned a lot. I made mistakes, and there were a lot of mistakes made in the case, in my opinion, too. But in the sense that I don't know how well we presented this, but I clearly thought that he met certainly criterion B or prong B of having deficits in adaptive functioning. That's what I did. The judge in this case did not find that to be the case, and he was sentenced to death. In 2015, he was scheduled to be executed. He got a stay of execution. Let me go back and say that the state's expert in 2006, when I was involved with the hearing and did my work, found that that state's expert did not find him to have intellectual disabilities. As I said, the judge rules in favor of the prosecution in this case, and Mr. Williams is sentenced to death in 2015. He gets a stay of execution the day of the execution. He gets it for actually DNA reasons, not having anything to do with ID. He gets another, a couple years later, in 2018, he gets another execution date. Now this time he has 16 days ahead of time when it's stayed. It's stayed now because of what I would call luck. He was lucky that in between there was another Supreme Court case called Moore versus Texas, where that particular Supreme Court decision found that we were not doing things here in Texas that was applying science and applying what professional standards were. And so he got another chance to prove his ID-ness, if you will. I was asked to get involved with the case again. Somewhat reluctantly I got involved, but I did. And this time, the same state's expert in 2006 that found him not to have ID found him to have ID. Now, I don't know where the case will exactly go, but I will tell you it's a very interesting situation of how things can change. And this guy came within hours of being executed. Now, I'm not saying that he shouldn't be doing time. I'm not about it. But it's a fascinating story to me, and I learned a lot. Let me do one thing before I thank you. There's two messages I want to leave with, and I want to turn this over to Mary. One of them is that here at UT, understand that you will learn things, you will get experiences, you'll get skill sets that can be used in an amazing variety of settings. I never thought as a special ed teacher I would be actually working death penalty cases almost every week. And the second piece that I wanted to just kind of share with you was related to the fact that it relates to actually this story and the other stories, and that is the death penalty and intellectual disabilities. It's messy, it's complicated. We need education. We need people to understand what ID is and then how to apply it in the world where major decisions are being made. All right, so now, thank you for listening. I appreciate it.
Our last speaker is Dr. Mary Rose, an associate professor in the Department of Sociology in the College of Liberal Arts, as well as in the School of Law. She is an expert on jury behavior and decisions.
I'm doing something a little different. I do research on juries and jury decision making and public views of the courts, and therefore I want to think about what your image is of the legal system and talk about how that isn't how the legal system works most of the time, and that it's a problem that that's not how that our legal system does not work in the way that you think, and our legal system doesn't work in the way that the founders intended it. And I'm not going to be focusing entirely on the death penalty here. I'm taking a little bit of a wider lens. So I think you may have heard that most cases that we have in the legal system are not solved through the kinds of processes that a jury sees and that a jury decides on. You may have seen this on Last Week Tonight, where he's done a couple sessions on the rise of plea bargains. You can, if you're fancier, you can watch on PBS, and you can go to YouTube and watch academics talk to each other about the ways in which plea bargains dominate our legal system. And this is very related to the death penalty, because one of the ways, a very effective way to get a plea out of a defendant in a state with a death penalty is to threaten the death penalty. And it becomes a tool to get someone to turn over their rights to a trial by a promise to avoid the death penalty. And this ends up being a system that I was sort of smiling at the title of the session, which is How Does the Defendant Plead? And I feel strongly that the defendant shouldn't have to plead. And what the defendant should have, in my opinion, is a jury trial or really any trial. But in our current system, that person probably will not have that opportunity. And this is, in my opinion, a reflection and a cause of a decline in our attachment to liberties and a decline in the way that we take seriously what the founders envisioned. So, how do I know the founders envisioned the notion of a jury and a jury trial? I read the Constitution. And so I literally am going to put it up here. In Article 3, which you learned in your civics class, is all about the judiciary. The second section of there says, the trial of all crimes, except as we're learning in cases of impeachment, shall be by jury. Congress takes care of the impeachment. And I note the language here, shall be by jury. And the vision there is, this is the way it is. This is what's going to happen. It wasn't until the Bill of Rights and the amendments get added that you actually see talking in terms of defendants' rights and defendants' choices. But they're very clear here. The added amendments, remember the Bill of Rights is 10 amendments, right? 3 of them make use of the word jury. So in the first sentence of the Fifth Amendment, no person shall be held to answer for a capital or otherwise infamous crime unless on presentment of indictment or indictment of a grand jury. That's the group that the prosecutor has to go to first and make sure that they can say to the grand jury, I have evidence to go forward. Why would the founders have cared about this? They're used to a system in which the executive branch they envision an executive using its power to go after citizens for political reasons. So how handy is it to get rid of an opponent except to throw him in prison? And the founders, your safeguard is that the state present the reason why they're saying this person should face a crime. This is the one you know as what I mean by jury, what we usually talk about by jury. It's just in criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district, etc. And then the whole Seventh Amendment is about civil trials. It's about the right that even when it's a dispute between you and a neighbor, between you and a company, between 2 companies, the idea is if it's a little bit more than a small claim, you have a right to a group of your peers to think about that and give their opinion on it. And what we've learned in my lifetime is how costly this commitment is and how it requires all of us to advocate. There is a scholar who calls the jury the 4th branch of government. It is intended as a check on every other branch. It is a check, as I've said, on the executive branch. It's a check on judges, so that somebody else besides the elite people who get the judgeships and are elected, at least in Texas, or are appointed by the governor or the president, that somebody besides that has a say. And they're a check on the law, because laws get passed, but people interpret them. And what we've seen is that trials have gone away. This is a graph of, in this case, civil trials in the federal system, but I could put up any graph about criminal cases in the federal system, criminal cases in the state system, civil cases in the state system. And the picture would look the same, which is trials going in to the floor, to where, in this case, less than 2% of all civil disputes are resolved by a trial, by any trial. Which means that vision of having citizens pass on legal issues has gone away. And that is, as I just pointed out, not what was intended. Now, scholars debate what's going on here. Scholars argue over why this is occurring. One issue is that trials are costly. It costs a lot to hold a trial. We have never had always all disputes handled by trial because they're costly. What you've seen is an aversion to trials now. It's that prosecutors have gotten greater power in what they offer to defendants, and it just becomes irrational to go to trial when you're facing the kinds of sentences that they're threatening you with. We don't fund public defenders' offices, so they have to pretty much plead out in order to do their jobs. We don't build courthouses, even though our population grows. All of these things contribute. But so on the civil side is the case that we've forgotten that the jury is a protection against elites. A jury is a protection to make sure that the powerful don't have a say over everything. And so what you're seeing on the civil side when you have a dispute, particularly with a large company, is that they ask you to give up your right. So how many folks in the audience have a Netflix account? Okay, or maybe your parents do. When you're clicking through to set up a Netflix account and you accept the terms of service, this is what you agree to in all caps. You agree that you are not going to go to any kind of trial with the complaint you have against Netflix. You agree that, except if it's a small thing. You agree that it's going to be handled by a company that Netflix contracts with to handle its arbitration. And that's how it is, and if you don't like it, don't use Netflix. And I think we can all say, well, okay, we'll do something else, we'll, catch it on YouTube or whatever. This notion we've talked about where a body is, you don't have much choice in these manners. There's a party that has all the choice. It pervades life. And so a few years ago, my father he'd been not able to stay in the retirement community he was in. He had dementia, and he needed to be moved to a memory care facility. I, who have studied juries for 25 years, in order to place my father in that facility, had to sign away my right to a jury trial. And there was no choice. There was no place to take it somewhere else. And in that particular situation, there was no option. Now, I want to close by being clear that I will not stand on a stage with Jordan Steiker, who is literally the nation's expert on the death penalty, or with Professor Patton, who knows how these things work in practice, and argue that juries always get it right. I am guessing I could pull you for some infamous jury verdicts, and you'd be able to name a few that you think are just blow your mind. The jury, like any piece of our system, is not perfect. But that's not what the founders were asking about. They were asking about a decision-making body and whether it's better than the alternatives. And in a democracy, what we've given up is the right to have a jury look at our cases. And I'm so thrilled that we've been talking about concepts like originalism, because I think this is such a great example of how we pick and choose what pieces of the clear written text are there, and we let others decide for us, particularly elites, decide for us that we don't have our rights. And I think the defendant definitely pleads far too often. Thank you.
Now is we're going to take just a few questions for the panel. And one of the things I want to start with is there was a very clear picture presented, and that is that, in fact, the system that we have in place is changing. and that it's changing not necessarily by design, but it's changing by a whole lot of other factors, that are the environmental factors that are influencing it. So I'm wondering if each of you could give a quick response to what do you predict? I'm going to ask you to make a bold prediction of where we're headed in the legal system as it relates to the death penalty. I'll start with you, Professor Steiker.
Well, I think I already made my prediction. I think that the death penalty is almost certain to disappear in the lifetimes of the folks out there, if not in our lifetimes. And I think that's because it's very hard to imagine that the United States won't be pulled along with this very, very strong global emerging consensus that the death penalty is sort of inconsistent with civilized notions of justice.
I guess my response would be, at least, and as you know, I'm going to stick to the right here. I'm dribble with the right.
Yeah.
And so that means in the area of intellectual disabilities, there's no question that as time has gone on, people have gotten more educated. I think defense teams are getting more knowledgeable about how to deal with this. I think they recognize they need to do comprehensive kinds of assessments. I think they realize that they have to work, that the work I do is not a singular thing. I have come to respect the fact that I work with mitigation specialists, lawyers, psychologists, neuropsychiatrists, I mean, a range of individuals. And on the state side, the prosecutor side, they have also emerged in terms of, I'd like to think understanding this, and my point was mostly about education. I think the more knowledgeable we are about intellectual disabilities, perhaps there's more of an understanding that maybe we don't have to go to hearings.
I'm kind of with Jordan that I predict that this will not seem like a reasonable, there will be a feedback mechanism in that juries are going to be less willing to return these verdicts, particularly as citizens learn more about how the system actually works, as opposed to the strong opinions they may be going in with. And I think it's going to be that particular feedback loop that can contribute to it. But I also believe there needs to be top-down.
So I have a question from the audience, and this is for you, Dr. Rose. Do you think there would be or could be an amendment to change the right to have a jury?
Amendments take how many?
2/3 of Congress and 3/4 of the states.
It takes an awful lot of consensus to get an amendment, and I am not saying that. And on the jury, a point I didn't make but feel strongly is this really should be one of those things. The support for a jury really comes and should come from the bleeding hearts on the left who care about the defendants' rights all the way to the most libertarian and folks who are most wedded to the Constitution. And so I don't know that we're going to see changes to the jury in changes to the Constitution. It's living the document that we have.
So Dr. Patton, could you just briefly outline what is the state of Texas's process for determining whether defendants in capital punishment cases have intellectual disabilities? So the process.
Here in Texas, usually what will happen is that there will be often, we hope, an evidentiary hearing that will take place prior to trial. And the reason that's actually fairly important is that you would like to deal with the issue of intellectual disabilities before you actually go to trial to make that determination. That evidentiary hearing, and most of the time I've been involved with it here, is usually done with a judge. It could be done with a jury. But ultimately what you'll have to do in that, and that's the key issue, is this hearing that will establish whether there is intellectual disabilities. The defense has the burden of showing that you meet those three prongs in the definition. So the answer to it is that the defense team has to put together a very strong argument that all three of those prongs are met. IQ, and I haven't gone into the micro details. There's lots of issues related to assessment, whether it's prong one on IQ or the assessment that I do, as well as even just argumentation on what's the developmental period. But basically there's a hearing, and in that hearing, both sides will get to present their side on whether this person meets the criteria.
I would just add one thing to that, which is Texas is the Wild West when it comes to this issue because most states actually have passed a statute implementing the exemption of persons with intellectual disabilities from the death penalty. So there's a clear procedure of when the decision should be made, who it should be made by, what the standard should be in terms of implementing that. And in Texas, we don't have a statute, so different courts do it differently. Some courts might hold a pretrial hearing. Most courts actually will say, we'll let the jury decide whether the person has intellectual disability, but only after they've decided that the person should be sentenced to death. After they've said that the defendant is a future danger and there's not sufficient mitigation to justify a sentence less than death, then we'll ask them, does this person have intellectual disability? Which creates this incredible problem of dissonance, because if a jury has already decided the person should be executed, it's hard to believe that you'll get a fair determination of whether the person has intellectual disability.
Yeah. We came close this last legislative session. When I say close, there was a bill introduced in the House that was actually a definition that I think almost everybody, both sides, prosecutors and defense folks, were very much in favor of. It crossed over into the Senate and things changed, and it never got passed. Yeah, to your point, Jordan, yeah, it'd be nice to have a statute, which we do not have.
So this one's for you, Professor Steiker, and it's two parts, and I think the second part might be the more interesting. Why does the death penalty cost so much, and can you break down where that money goes?
So the death penalty costs so much more than non-capital trials because the stakes are so high. There are different entitlements that just don't apply in non-capital cases. So in a capital case, you're entitled to 2 lawyers. You're entitled to do an extensive investigation about mitigation. That can often take a couple of years before you could actually go to trial for all of that work to be done. The lion's share of extra costs happen at the trial. If you're sentenced to death, but only if you're sentenced to death, you're entitled to a lawyer if you're indigent in subsequent appeals and state habeas proceedings in federal court. So if you're sentenced to life in prison and you're indigent, when your conviction's affirmed, that's it. Even though you're legally entitled to an appeal in state post-conviction, and even though you're legally entitled to challenge your conviction in federal court, almost nobody has a lawyer and nobody does. The costs of death row confinement are so much higher. In California, it costs about $15,000 to confine someone in the general population of a prison, but in the solitary confinement style death row incarceration, it's about $90,000 per year. And if you multiply that by, close to 800 inmates, that's $75,000 up to, it's a ton of money. So the costs of the capital system have just sort of been the weight that have really brought the system down.
Okay. Final thoughts?
I'm so glad we had this session.
I would just say I think everybody should be aware of this issue and thinking about it. And I just think the more educated we are, the better off we will be.
Well said. Well, thank you, everybody. I hope you found this interesting. And let's give these amazing faculty members a round of applause.